All right, well, we're going to get kicked off today as folks come in from the Zoom waiting room. Thank you all so much for being here for this really, really important talk today. We're super honored and glad we're having this important discussion. So it's C+B Community Talk, a special edition one with the Office of Equal Opportunity in Title IX here at DU. And this is a discussion on the Department of Education's proposed Title IX regulations. And so on July 12th, 2022, the US Department of Education published proposed Title IX regulations for public comment. And we want to provide a space for folks to talk about that, what that means, if they want to take action. And so we recognize this change, if implemented, would alter the way that colleges and universities respond to gender-based violence. And so we think this is a really important space to have. And before we get it kicked off, I do want to start with a land acknowledgement, as we do with all of our Community Plus Values events and programs. And so I do want to take a moment in the spirit of healing, and peace, and justice to acknowledge and honor the indigenous peoples of the land upon which the University of Denver stands, the Arapaho, Cheyenne, and Ute tribes. Like the history of so many institutions in the American West, ours is complex and sometimes painful. In recognition of this fact and to underscore our commitment to inclusion and equity, we commit to listen to and affirm the stories of all in our community. We do invite you to visit DU's Native American and Indigenous Initiatives website to learn more about what is going on in DU. And with that, I do want to share Provost Mary Clark was going to be moderating this conversation today, and she unfortunately is not feeling well, and we're so glad that she's getting a chance to rest and recover and heal up. So will be moderating the conversation today. I'm super honored to be in the space with the folks on this call. And today we are joined by Emily Babb, is the Associate Vice Chancellor for Equal Opportunity in Title IX here at the University of Denver, and Dept, who is a Distinguished University Professor and Associate Vice Provost of Public Good Strategy and Research at the University of Denver. And lastly, Molly Hooker is the Deputy Title IX Coordinator in the Office of Equal Opportunity and Title IX here at DU as well. So thank you all so much for joining us. We're looking forward to having a conversation about how folks can learn more, but also take action. So we'll be digging into those. And so with the first question, we're going to dive right in here today. I do want to let folks know that there is live transcription available. So if you do need closed captions, you can press that little button down on the bottom right, and a transcript options will pop up for you. And they will also be available via the web recording afterwards as well. And if you do need anything, the chat is open, and we will have a Q&A time at the end. So we'll have 15 to 20 minutes for folks to ask questions, get clarification, and share resources that they might know of as well. We'll be sharing those also. And so if you want to use the chat function or the Q&A box, both of those are available for the talk today. And with that, I'm going to kick this one over to Emily to start us off. So we're going to dig in on what changes should community members be aware of in the proposed Title IX regulations.
Thank you so much, Jason. Thank you for working with us and having this important conversation today. My name is Emily Babb, and I'm the Associate Vice Chancellor for Equal Opportunity in Title IX. But before joining DU, I spent 12 years at the Department of Education in their Office for Civil Rights, investigating and responding to complaints of discrimination, harassment under a number of different civil rights laws Ed is charged with enforcing. So with that, I bring the lens of both a Title IX practitioner and a former Department of Education attorney. So what we wanted to do today is really set the stage and talk about the notice of proposed rulemaking that was published in the Federal Register in July of this year. The Department of Education is responsible for promulgating rules to interpret Title IX and other civil rights laws. And the law itself, Title IX, is short, right? It's very, very small. But the regulations are what really tell colleges and universities and other recipients how we should be implementing that law. So to start the stage, we want to highlight some of the key proposed changes that the Department of Education has put forth in this Notice of Proposed Rulemaking, or the NPRM. It's important to understand that these are not final rules. These rules have not been adopted by the Department of Education. They have not gone through the full process. This is the Department of Education telling us as recipients, colleges, and universities what they anticipate doing. And so we're really in that opportunity to understand what they anticipate doing, respond and provide feedback, And then they have to respond to that feedback. So in 2020, when the proposed rules changed pretty drastically, the Department of Education received 125,000 comments from the public, and they had to respond to all of them, not individually, right? They kind of grouped them by theme, but that resulted in over 2,000 pages of explanation. So that's the stage we're in right now. So some highlights, what I'd like to do is just highlight some key proposed changes that I think the university community wants to know about and may have some need or desire to comment or really think about. So the first thing I want to share is really the scope of the notice of proposed rulemaking. So in 2020, the Department of Education very narrowly changed the scope of Title IX to be in the United States and in the education programs or activities, which they very narrowly defined as where we as an institution have control or exercise authority over the individual who engaged in the conduct and the location and circumstances. So these proposed rules remove that jurisdictional tie to the United States, which means it opens up conduct that could occur outside of the scope of our physical geography in the US, such as student study abroad. Now, our office, DU, has been looking at this type of conduct under other processes. We didn't get rid of it, but this is a significant change. The scope also changes from that very narrow education program activities of where we exercise control over the individual and the circumstances to a broader statement of where we would have someone subjected to our disciplinary authority. So really the department is offering a broader scope again of where as an institution we may want to regulate and respond to conduct. Another key change we want to highlight is around the definitions. So the definitions under the current 2020 Title IX regulations are more restrictive than the NPRM is proposing. So in addition to expanding the scope of sex to include sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity, the department is also proposing a revised definition for what was called sexual harassment, and the department is now calling sex-based harassment. So that updated definition for hostile environment harassment is proposed to be unwelcome, sex-based conduct that is sufficiently severe or pervasive that based on the totality of the circumstances and evaluated both subjectively and objectively denies or limits a person's ability to participate in or benefit from the university's education program or activity. That definition change is key on a couple different areas. First, the department is proposing to remove an and, a very important and that was added in 2020. And that and required severe, pervasive, and objectively offensive. Second, they have added back, they have removed effectively denies and replaced it with denies or limits, meaning that impact on the ability to participate in program is broader than simply a denial, right? Really acknowledging that conduct can impact students and employees in a number of different ways. And finally, the department has proposed factors to consider when determining whether a hostile environment exists, such as the degree to which the conduct affected the individual's ability to access their education program or activity, the type, frequency, and duration of the conduct, the ages of the individuals, their roles, the location where it happened. So these are more descriptive factors that the Department of Education is giving to colleges and universities, as well as K through 12, to help them understand whether a hostile environment exists. Another key aspect that we want to highlight is really around response and investigation. The current 2020 Title IX regulations require colleges and universities to provide a live hearing with the opportunity for cross-examination conducted by an advisor of the parties or witnesses. The notice of proposed rulemaking gives greater flexibility to colleges and universities to determine who is the decision maker and whether to have a live hearing. So for example, the NPRM allows the decision maker to be the same person as the Title IX coordinator or the investigator, and also allows for a process that does not require a live hearing. Now, the department's proposed rules do say that when there is no live hearing, there must still be a process by which the credibility is assessed of the parties and witnesses, and a process that would allow the parties to propose relevant and not otherwise impermissible questions to be asked. So this really gives colleges and universities an opportunity to look at what is right for their university community, whether that hearing is something to continue with or whether a non-hearing model is there. This flexibility, I think, can be really helpful to colleges and universities who have varying resources, varying processes. Now, they have retained a number of pieces from the current regulations, such as the presumption that an individual is not responsible for, and that presumption must be overcome, reasonably prompt timeframes for the investigation and critical stages, and some flexibility in terms of how to conduct those investigations. Also, the department's proposed rules would require preponderance of the evidence, which is more likely than not just the current evidence standard that the DU's policies use, unless an institution were using a different standard, which is clear and convincing for all other forms. So really giving some guidance of when and what type of evidentiary standard should be applied. And I think the final thing I want to highlight for you all before passing on to my colleagues is really the department's intentional addition and expansion of protections for pregnant and pregnancy-related conditions. Just prior to the publication of these proposed rules, the Department of Education issued a resolution agreement involving a community college in Salt Lake that really addressed how colleges and universities should be providing accommodations to students who have pregnant or have pregnancy-related conditions. So they've really called this out in the notice of proposed rulemaking, and a number of key ways. First is to make sure we're making clear to our university community that pregnancy discrimination is covered by Title IX. Second, telling individuals that if they do disclose a pregnancy, that they should be informed about the Title IX coordinator and that they have the opportunity to request accommodations, modifications, access to separate or comparable portions of the programs, allow voluntary leave, and also ensuring the availability of lactation space, a very specific and new call out from the Department of Education in these notice of proposed rulemaking. And really telling Title IX coordinators such as myself that we must effectively implement, coordinate, and document those modifications for our pregnant students and employees and those pregnancy-related accommodations. This is the first time the department has really given a little bit more clear guidance on what they are anticipating from that. So those are some of the highlights that I wanted to bring to your attention. There are many more that have some nuances in terms of new requirements for training, and so far as all employees will need to be trained on what constitutes sex discrimination, the scope of our policies, and how to report that to the university, and requiring the Title IX coordinator to monitor the programs and activities of the institution to really see if there are barriers to reporting. So there's a number of really asks for our equal opportunity Title IX office in these proposed rules, but these are some of the key highlights I think might be important to our university community.
Thank you so much, Emily. That's so helpful to learn, and we're getting some great questions in for the Q&A. Thank you to those who have submitted them thus far. I'm curious if anybody else wants to jump in on that first question around changes that community members should be aware of in the proposed Title IX regulations. All right. Well, this is a great question and kind of ties into one that we got from someone in the Q&A. How would the proposed Title IX regulations change how universities respond to gender-based violence? And for this one, I'm going to hand the mic to Anne on the call here.
Thanks, Chase. Good morning. I'm so glad to be with everyone. Thanks for the opportunity to talk with you. I'm Anne Prince. I'm a professor in psychology, where my research focuses on trauma, particularly intimate violence, including gender-based violence. And I also work in the Provost's office as the Associate Vice Provost of Public Good Strategy and Research. So these kinds of conversations where we come together to talk about policies that have an impact, when we also have a time frame in order to share our opinions, including with the Department of Education, are particularly exciting to me. Researchers, I come at this through the lens of a researcher. I don't have any bearing on how DU ultimately implements these rules, though I'm very glad for collaboration over time with both Emily and Molly and colleagues across campus to address gender-based violence. But looking through that lens of research, I think there are a couple of things that stand out for universities nationally. One is a lot of really trauma-informed kinds of changes in these proposed rules. For example, the moving back from the requirement of a live hearing, I think, is a really important change, not only to provide universities the kind of flexibility that Emily described, but also to think about processes that are fair for both the complainant and the respondent, the language that the Department of Education uses to describe people bringing forward allegations and responding to allegations. There's been a concern from the survivor as well as the research community that the live hearings really mimicked the criminal justice process, which Emily teed this up by pointing out this has to do with civil rights, our right to education, regardless of our gender identity, and the different dimensions that Emily referred to. And that live hearing really was bringing in a lot of aspects of the criminal justice system, which this is not. And there are ways for universities to have fair and equitable processes that don't involve that live hearing component. So I think there are some very promising changes that will allow universities to think about equal access that isn't re-traumatizing, potentially re-traumatizing, and very stressful for survivors. I think also, though, there are some places where our community may want to think about and potentially comment on the rules. So, for example, there's a lot, as has been the case in prior rules, around mandatory reporting. And many researchers have been thinking that the Department of Education, in trying to correct problems of treating campus sexual assault and harassment as taboo and sort of shuffling it under the carpet, that the pendulum has swung very far to make it so that nearly everybody is a mandatory reporter. And these rules include things, and Emily, please correct me as a non-lawyer if I'm wrong, but do include things like if we as employees were to learn about a sexual assault, say at a Take Back the Night march, we end up there in mandatory reporting roles. There are some folks around the country doing really important work to argue for mandatory supporting instead of mandatory reporting. So how can we train all of our employees to be responsive to what a survivor wants, respect their autonomy for decision making, and have mandatory reporting fall to key people who have the power at the institution to initiate the kinds of processes, investigative processes, response processes, such as chairs and deans in the Title IX office. And so I think that's something to really grapple with. And I, as a researcher doing survivor-centered feminist work, I do love the idea of mandatory supporting being part of how we're approaching this, so that we are sure not to replicate problems of not recognizing survivor autonomy. But that's one of the issues that I think is a little bit stickier in the rules, where people have, I think, a broader array of potential opinions about whether the rules have refined enough to recognize what we know about the importance of autonomy and survivor voice after a trauma. So pass it off to my colleagues.
I'm happy to jump in here, Anna. I think you made some really great points around public awareness events, such as Take Back the Night or other Speak Out events. And the Department of Education actually kind of acknowledged that in these proposed rules, and said that, and specifically called out public awareness events around mandatory reporting, because this does take it where the current regulations focus on the authorized official and more narrowly define that. The proposed rules do expand it back out. I would say not as far as some of the 2014 and 15 guidance that Ed had in the form of Dear Colleague letters, but here in these proposed rules, they both define what a confidential employee or confidential resource is, which is a new definition, right, for the regulations, and acknowledges both the privilege, so some, medical privilege, doctors have privilege, confidential advocates may have state privilege, but also those kind of confidential designations by institutions, right? So where we have determined, even without a privilege, such as maybe an ombuds or a chaplain or a confidential resource that is not based on the state privilege, but has been determined to be that at an institution. But as it goes to public awareness events, the Department of Education's rules call those out, right, and say that that is not reportable under this proposed rules, but rather should inform the prevention efforts for the institution. So thinking about how we as an Office of Equal Opportunity in Title IX really engage with those public awareness events to understand that this may not be a reporting of an incident, but rather a sharing of a climate or a concern or a pocket or area where we need to focus our prevention efforts. So I think that's really good as we think through kind of what the current state, where we're going, what this might look like, how we want to define, so that we are getting folks to the people who know how to respond, right? Who give options, provide supportive measures, but also giving that flexibility and maintaining those confidential resources at the same time.
That's great, Emily. Thank you for the.
Oh, and you're on mute.
And, yeah.
Oh, such a classic error. Thanks, Emily, for the clarification, and also the thinking about the community and training and making. And I know that in the past it has been part of the training, and it's exciting to think about building that out going forward so that we all understand where and how to refer to our colleagues across campus for different kinds of both the prevention as well as the response side of things. So that's quite exciting. Thank you.
Yeah, I just want to work in one question here. I so appreciate the person asking this. And they asked, does the mandatory reporting apply to only minors or to anyone? And I thought it'd be a great learning moment if someone could jump in and answer that one live.
Yeah, that's a great question, because we've really tried to shift our language here at DU to clarify the difference between that Title IX reporting and that child abuse reporting. So in previous procedures, we kind of called everything mandated reporters, right? And in the 2021-2022 academic year, we really shifted that language to responsible employee being those that are required to report under our discrimination and harassment policy, which is broader than Title IX. So those who are responsible employees at our institution, which is broad, and I will share that we are on the broader side of things, have to report both discrimination and harassment on sex, but also on other protected statuses such as race, color, national origin, disability, age, military status, enlistment, veteran status, genetic information. I'm sure I'm missing one. I always do: gender identity, gender expression, sexual orientation. And so we really have that broad requirement, which we call responsible employees. And that's outlined both in our procedures, but also in a new reporting policy that we've published for this academic year to really clarify who's responsible and who's confidential. Now, that mandated reporter typically is going to come from that child or minor child abuse reporting. And mandated reporting is under state law. We also have policies around minors on campus that talk about the obligations for certain individuals to report suspected child abuse. So we've really intentionally tried to create a little bit of a divide to understand there is overlap, right? A minor who has experienced sexual violence may need to have that both Title IX responsible employee reporting and that mandated child abuse reporting. But there are a whole host of types of prohibited conduct that wouldn't require that mandated reporting under state law, but are still have that reporting under our policies and procedures. So when we, in the beginning of the fall quarter, we always share our new updated procedures with the university community, where this year we'll be doing that in early September. We also will be sharing that a new reporting policy, which is available on the university's policy repository, which really just takes those definitions that were in our procedures and clarifies them so that people can really understand when they need to report, how to report, and also most importantly, what to do if you're not sure, which is always feel free to reach out to our office. We are happy to answer those questions of, I'm not sure if I need to report this. Here's kind of what's going on, and we can walk you through whether that's a yes or no.
Thank you so much, Emily. I'm learning so much even on this webinar, so I so appreciate that thoughtful response and jumping in on that question. And now we're going to kind of go, we went from a macro scale, and I'm going to turn to Molly on this one of what impact will the proposed Title IX regulations have on how DU responds to reports of gender-based violence?
Hi, Molly Hooker, Deputy Title IX Coordinator in the Office of Equal Opportunity and Title IX. I have been at the institution since 2001 and have really been a part of most of the changes through the Title IX progression. So really happy to still be part of it. And thank you for having me as one of the panelists today. And thank you for the question. I know that we actually have already discussed the responsible employee part of the proposed regulations, but I do want to say that for our community, how we would respond to reports of gender-based violence if in the new regulations they would require us to take prompt and effective action to end prohibited sex discrimination that occurred in an educational program or activity, prevent its reoccurrence, and remedy its effects. I do think that our model that we currently hold at the University of Denver would be bolstered by the new regulations, which is to get the information to our office of those that allege discrimination, harassment, and gender-based violence so that we can offer support and options with the goal to keep them engaged in their education. I ultimately see that is our role with the institution. And while some some of it may feel uncomfortable to actually get that information to us, as Dr. DePrince was saying, thinking of a trauma-informed lens with it all is really important, because ultimately the goal is to connect with that person and make sure that they still can think through, how do I access my education? How can I continue to go to classes? How can I continue to walk into, whatever building and feel like I can access my education? And so ultimately I see that as still a really big connecting point with our office and what these new regs are bolstering. And that is through really thinking through when somebody is feeling connected enough with an employee at the institution to disclose this information, how does that employee then get it to the right office to help think through how to access their education? And so I see that as our opportunity is to continue working on that, which would be through education of our employees, right? How to teach them how to appropriately respond to somebody that's disclosing that information, how to get it to us appropriately, how to help that person understand that what our goal will be is to help them continue to access their education and offer them options on if they want to address it. In addition to really walking through all the other regulations that may come through, is just making sure that all of our procedures and our policies are well understood by the community and that we're implementing them effectively in a way that works both for anyone participating in our process, but also that we're just really being thoughtful about the concept of Title IX, which is to really help access your education on the basis of sex free from discrimination. So if we hold that concept high and just do our job as trying to carry that through, I think that's really our role with it.
I love all that you shared, Molly, particularly around the, to pick up that trauma-informed thread a bit. I think sometimes we, lots of us use that term and mean different things by it. And I think one of the things I love about C+V hosting this conversation today, and Emily and Molly helping all of us in the community learn more, is that a pillar of trauma-informed institutions is really around transparency and clear communication. And so this and other efforts that your offices have made to share what the rules say and how DU is often going above and beyond that. You know, the rules are about compliance, and then that compliance isn't necessarily as good as we can do as an institution. But I just wanted to mention that transparency piece, these kinds of conversations are literally part of building a trauma-informed institution, and such a pivotal piece of that, along with some of the other pieces we're talking about of how do we collaborate across offices with academic departments in order to respond. Collaboration is key to trauma-informed institutions. And then also pieces around empowerment and voice and understanding the history of how we've gotten to where we are now, so that a place where harassment, abuse, assault continue to affect some of our community's education, that those being aware of those historical and systemic things so that we can be addressing prevention going forward is also part of being a trauma-informed institution. And these kinds of conversations are essential to that work going forward as well.
And thank you for that about transparency. I think that's been one of the key, and really thinking about this beyond compliance, because we do find ourselves as named as a compliance office, but we think of ourselves as so much more than that. But in that interest of transparency, one thing that we've really been doing over here, and this is kind of to go along with that, is giving information to the university community. So we publish an annual report every year. You can find it on our website. You can see how many reports we've received, what types of things we've done with them, what types of complaints we're receiving. And I think that can go a long way in transparency in this process too. As we closely follow the Department of Education's proposed rules, we know that we are staying up to date with what is happening as Q&As changes, with litigation that might impact the proposed rules or the current rules. And how are we telling our university community that? When we made updates to our policies last year in response to some Department of Education guidance, we were very transparent and said, we're removing this piece of subjecting yourself to cross-examination and what that means because of these reasons, and really highlighting those changes. So as we move through in this process, we will make sure that we're highlighting to the university community any changes that we have to make, right? Even if we don't like them, sometimes we have to make changes based on these rules, and the ones that we're allowed to make or have flexibility in, and really getting that input, right? There are times, as we know in the implementation of the 2020 regulations, where we were told we had to do something, right? Which may or may not have met what our community wanted. But then we had some flexibility on how we did other things. And that's really where we can engage and have that continued conversation and transparency.
And that segues perfectly into this next question, Emily, and I'm going to hand it right back to you. In terms of what will they be taking any action now in response to the proposed Title IX regulations? What does that look like for DU?
So we are not changing our procedures in response to the notice of proposed rulemaking because they are not final, right? And so we really want to make sure that we are not making changes that don't find themselves finalized. When we saw the proposed rules in 2018, they came out in November 29th, 2018. They were not published as final rules until May 14th, 2020. And there were major changes between what was proposed and what was final for the better, right? The department actually did listen to some of those comments. And some of the things that we were most concerned about were not implemented, such as, specific types of evidentiary standards and mandated, if you have this, you must do that, and things like that. So right now we're sitting tight. We're watching we're waiting. We have published new procedures, which are for the upcoming academic year, as we do every year. Not major changes in there. We really just make sure that they continue to meet our needs. Those are available on our website. But again, those changes weren't in response to the notice of proposed rulemaking, because we really are waiting on those final regulations. And really making sure that we're responsive. We know this could be a quick process, right? There's a 60-day notice period, and then the Department of Education has to review the comments. But there are a number of layers of kind of bureaucratic review that the Department of Education will have to go through. So it's not a quick pivot, probably. It's a period of time, but we're hoping that we will both, one, see them soon, right? And then two, have plenty of time to implement. I think one of the biggest challenges that colleges and universities face is when we do get new regulations, when will they be, right? Mid-academic year is probably harder than during the summer, where we can change between academic years. And how long will we have to implement them? When the 2020 rules came out, we had about 90 days, right? Which is lightning speed for changing policies, especially when there are large policy changes. So really looking and kind of closely following that and making sure that we're set up to respond as quickly as possible.
Thank you so much, Emily. And Molly, did you unmute? Did you have anything to add, or?
I actually just remained on mute, so thank
Perfect.
you.
Just wanted to honor you in that space. That sounds good. And one of the things that I think is most powerful about DU, and I love about this community, is that folks want to take action. They want to get involved. They want to try to make their voices heard. It's a part of our 4D experience. It's a part of all that we do here at DU. And I want to pass this one over to Anne of how can a community member get involved and provide feedback to the Department of Education around this topic.
Yeah, as Emily alluded to, these rules have been posted as proposed rules, and anyone is welcome to submit comments. And I'm quite proud that my research team, in collaboration with Dr. Shannon Sleva, back when what became the 2020 rules were proposed, we were among the 150,000 or 125,000, excuse me, comments that were submitted. And what our team did was take a collaborative approach. So we went to webinars like this. We learned about the proposed rules. We read up. And then we pulled on, in our case, our research expertise. We took things from our research team, lessons, other things we read in the literature, and used that to put together some arguments in a letter to the Department of Education around pieces of the rules that we thought were problematic and where our opinions were coming from. We certainly saw researchers across the country, experts in higher education, come forward and bring that academic expertise to the comment period. But I also want to mention how pivotal survivors and friends of survivors, allies who have direct experience with the issue have been in guiding the development of Title IX over time, whether that's survivors bravely coming forward in lawsuits when they have experienced discrimination through harassment and campus sexual assault, or the ways that survivors also organized to provide comments during the prior period. And so it is not on a survivor's shoulders to have to do anything in these processes. And yet I do want to acknowledge just how critical the survivor movement, survivors have been to calling for the kinds of change that are needed for all of us to have full access to this education environment, this academic environment. And I think one thing to remember as you're thinking about what your interest in this issue might be is we all benefit when our classrooms are free from bias and discrimination, when we can all show up as co-learners and take part authentically in this education enterprise. We all benefit from that. And so no matter what perspective you might be drawing from, you have an interest in this issue. These policies will affect all of us on campus. And so each person on this call in your networks have an interest in sharing what you like that you're hearing, or what you're concerned about in this window when we have the opportunity to affect federal change. And then we all have an interest going forward in continuing to be part of these conversations, because if we can get to more trauma-informed classrooms that are more equitable, again, we all benefit from that. So I think Emily's got more information on sharing in response to the rules.
Yeah, so I think, so I'm the nuts and bolts person, right? And think about like, how do you actually do that? And I really appreciate, Anne, your point about how you can really comment from a variety of different perspectives. And there are a number of advocacy groups out there who are calling on, students, employees, individuals to share their experience as part of the commenting process that they can then get to the Department of Education. And the Department of Education, before they even published these proposed rules, had a number of listening sessions. In fact, they had listening sessions with students from different groups. They had listening sessions with practitioners, with researchers. So, they are taking in all of this information and really do want to hear from the public. So to do that, Chase is going to drop the chat. Oh, good, great. Chase, drop the link to the rulemaking portal. So this is the portal in which to submit a comment. All comments must be submitted on or before September 12th, 2020. 2022. Oh my gosh, I went back 2 years. 2022. And the Department of Education is going to review and respond to those comments. They have a team of staff who are charged with doing that. Folks in their program legal, folks in which is a division of the Office for Civil Rights, folks in other pieces of the Office for Civil Rights, and they are going to look at and kind of group those comments together when possible, and then respond. And what we saw in the 2020 regulations was they'd say, we've got these types of comments. Sometimes they even cited to the specific comment that they received, and then explained how they considered it, what factors they weighed in deciding whether to keep the proposed language or choose different language. And that information, which we call the preamble, is really also quite informative for how the Title IX rules are being implemented. So those questions and those comments that are submitted by the members of the public can really help shape the regulations and also shape our understanding of why the Department of Education made certain decisions. So as I said, in 2020, they received over 125,000 comments. It was very active. So we definitely want to make sure that you have the opportunity to really have your voice heard, whether it be as an individual or as a group, a student group, an employee affinity group, a research group. You really can have that voice be part of the decision-making process.
Wonderful. Thank you so much, Emily. And with that, we're going to go into our Q&A section. We've had a number of really great questions, and there's a number that have gone through the Q&A and through the chat. And so I wanted to throw out one right at the beginning here and ask you all. They asked, my understanding is that Betsy DeVos made it harder to sue for sexual assault. Do these proposed regulations reverse that? So what does that look like in terms of previous things that have been done in that and then these proposed changes?
I think as a lawyer on the call, Chase, I'll probably take that one, although I'm not giving legal advice. I will say that the proposed rules don't specifically talk to the private right of action, right? The ability for an individual to sue a university, or to sue the Department of Education, right? A number of nonprofit organizations have brought litigation against the Department of Education as it relates to the 2020 regulations. So I think what this question is probably asking is, when the 2020 regulations came out, they did narrow the scope of Title IX, right? So they narrowed it both in the physical geography to the United States. They narrowed it to the education program or activity. They narrowed it to the definitions of sexual harassment being that severe, pervasive, and objectively offensive. So whereas an individual could have perhaps brought suit under for failing to take action around more expansive definitions of harassment, those rules in Title IX definitely narrowed that down. So I think what the questioner may be asking is around that scope of Title IX, which then kind of drives litigation. So these proposed rules do expand back out, not as far as the 2014-15 Dear Colleague letters had, but do expand back out those definitions around sex-based harassment to include more that severe or pervasive, which is more aligned with the Title VII employment definitions of harassment and hostile environment.
Thank you so much, Emily. Yeah, and I truly appreciate you bringing the legal and law perspectives to this, because we know there's so much interaction between that. And I'm going to give you another one here that's tied to that, that asks if you could talk a little bit about how Title IX may protect students. These proposed changes may protect students who require abortion care. We know there's some interactions intertwining between these two issues, and I'll go ahead and share the link to our previous C+B community talk that dives more in depth on what the new Dobbs decision looks like. But could you talk a little bit about that, Emily, or anybody on the call that has that expertise?
Yeah, I can speak briefly, right? And so I think I would definitely encourage folks, if they didn't attend the Dobbs C+B, it was fantastic. It really delved into that decision and you know, answered a lot of questions, brought up some more questions, right? I think as that decision does. But the Department of Education's proposed rules do define pregnancy or pregnancy-related conditions very much more broadly to include, you know, pregnancy, post-pregnancy, miscarriage, abortion, right? So termination of pregnancy. So if there's discrimination based on these types, or if there's accommodations needed for not just pregnancy, but these other pregnancy-related accommodations, these proposed rules would also give our students and employees access to those accommodations for not just pregnancy, but post-pregnancy, miscarriage, termination, and the like. So while not, you know, completely aligned in every aspect with Dobbs, there are protections there. This is something we're definitely looking at, right? As we have had a number of conversations with other groups in terms of being on webinars and thinking through kind of how these two pieces play into effect. I think there could be some addressing of this in the commentary that comes out of the proposed rules, because the proposed rules and the Dobbs decision came down proposed rules first, just a few days later Dobbs, right? So they didn't have the opportunity to really address them. So I think there are protections for students and employees who may have experienced or need accommodations for pregnancy-related conditions, which can include termination. But we really do have, I think, a little bit more to hear from the department as they address this. I would anticipate, in my crystal ball, that someone would likely comment on this, which could then drive some decision making and some answers from the department.
Thank you so much. That's incredibly helpful. And this next question ties into kind of a larger national scene around universities. And so if there are universities who want to minimally comply with the regulations, do these changes make it easier for them to limit their support? What does that look like in terms of how they provide support, how they comply on a larger national scale?
I'm happy to jump in here, Anne, but if you have kind of from your research perspective, I'd look to you too. I think when we went from the pre-2020 regulations to the 2020 regulations, there were much more restrictions, right? So colleges and universities could make a choice to narrow down and just look at the Title IX rules. I will say many of us did not do that, right? We retained our harassment and sexual assault and sexual violence definitions that cover conduct that occurred off campus, because there is an interest that our students and employees feel safe and feel that they can access their university, you know, their education program or activity, as Molly indicated. And that can mean that those things that happen off campus can impact their ability to come on campus. So these proposed rules expand on the 2020, right? They changed them. So I think there are still limitations, right? There are still these kind of guideposts and guide rails the department has put in place. But I think there is more flexibility and less rigidity down to that very, very narrow.
I think I would add to that, to Emily's comment in terms of, you know, constantly going back to these rules, these guideposts and guide rails as a minimum, And one of the things that DU can do to continue to distinguish ourselves is around building a culture where we are transparent and responsive and seeking to prevent harassment and assault before it occurs. And that is a really important part of, should be an important part of the character of any college or university. But this is an opportunity to lead, to take the infrastructure that's required and build upon that, to think about the incredible work that our colleagues in the Health and Counseling Center are doing around health promotion, to continue to make sure offices such as those talking to our colleagues about and new students about consent, about bystander interventions, that these are really a robust part of our experiences here as a DU community. And so, yes, there will always be institutions who can make a choice to address these minimum standards as their maximum. We at the university, in lots of ways that Emily and Molly have alluded to, have been interested in going beyond that institutionally. And I think that's really important. One of the things that we see coming out of the research literature is how damaging it can be when an institution adds to the betrayal that a student experiences after a sexual harassment or a sexual assault. And the flip side, we need to better explore and understand, and that is how can institutions show courage? What can we do beyond the complying with federal rules to really show robust care for our community members in the ways that we support prevention and thriving and health? And that is yet one more dimension that we really have an opportunity to lead and be distinctive here at DU.
Thank you. And I also do just want to say that I've really been proud of the efforts and collaboration among professors, among offices, from the administration support and really direction, getting good guidance from our chancellor on new initiatives. I can think of some of the things that we didn't mention that we're also trying to do around prevention, which is the Culture of Respect initiative from NASPA. So we're really looking at new preventative efforts. We're looking at healthy masculinities as coming onto our campus as, making a bigger presence on our campus and thinking about programming and awareness around that. The opportunity for us to really be thoughtful around what's the difference between training and education. I mean, we can all say that we do trainings or that we offer them, but does it actually cross the threshold over into education and making a difference? So I do want to say that is where we are as an institution, is really trying to, understand that, the compliance is the floor.
Yeah, and I think this is a really great time. There's a question that came in. How can we as an academic community ensure that accusations coming out to the classroom don't create a culture of fear, or that they will have unintended consequences of faculty tiptoeing around delicate issues or avoiding addressing them altogether? And I think this could even go beyond faculty to just all folks at the institution. But what does that look like? How do we have that courage that you were talking about, Anne? What does that look like day to day at the University of Denver?
I'm sure we all have takes on that. I'll come off mic first to say that I think that we're back to some of that trauma-informed. What does it mean to be a trauma-informed institution and have trauma-informed classrooms and co-curricular spaces? And a lot of that is transparency. So being clear in our own minds of what the rules are and expectations of DU, and being clear with our community members so that they can make choices about when to share their voice and when not. I love this question because the answer is not to not talk about these things. It's impossible to look at incredible literature or take social science classes or public policy classes and not engage with this topic. It is part of unfortunately, a part of human experience. And so we have to grapple with this and other complicated issues. And so I think the key is understanding what we're asking of students in terms of what a disclosure in different environments means and what that evokes in terms of our responsibility for care as a community, and beginning with that clarity so that we are not avoiding. If we avoid talking about things, about these important issues, we're cutting off an important policy issues, social science research, et cetera. So I think it begins with clarity so that folks can make informed choices about what they share their direct experiences with whom and when, and under what conditions do they share those. So thank you for that terrific question. I'm sure Emily and Molly have thoughts as well.
And I think I really appreciate your bringing the classroom kind of faculty perspective on this, because we know it's difficult, right? And I think that as we receive complaints or reports in our in the Office of Equal Opportunity in Title IX, we want to give options to folks. We want our students and employees to understand that there's a wide variety of things that can happen. We can take no action, right? We can honor a preference to not move forward. We can, try to resolve things through our informal resolution processes, which tend to be more restorative, educational coaching, or facilitated conversations. But we also have the ability to open up those kind of investigations to really look at what's happening. And I think the key to understand for faculty who may be experiencing that or concerned that they are going to experience that as they're navigating these difficult situations and conversations is really to understand that we don't want to not give people an opportunity to come forward with concerns. We want our university community to feel safe enough to raise, issues that they're experiencing. And then with that comes a neutral process. Like our office, the Office of Equal Opportunity, does not represent students or employees or one party or another party. We come at that from a neutral perspective and really a deep, inquisitive fact-finding to understand what's happening and to understand the impact that may have had on all of the parties involved, including witnesses and individuals who serve in those roles as complainants and respondents. And it's really important to know that we come to those kind of inquiries or investigations or even informal resolutions with a presumption that the policy's not been violated. We presume that that both the complaint or report has come in good faith and that the policy's not been violated, which seems at times to be contradiction, right? Because that really puts us in that very neutral place, that really neutral space. And so I think bringing those two perspectives of kind of, really engaging in difficult conversations, but also knowing there are these guide rails and, kind of to keep us in that place where we're looking at things from a neutral perspective.
Thank you so much, Emily. And Molly, is there anything that you'd add? And one question we did come in that I thought would be great if you could touch on too, when you talked about the cultural respect and some of that work, was how do we be more even proactive in these conversations? A lot of this ends up being reactive, but what does it look like for teaching, for learning, to make sure that folks are having these important conversations?
Well, I do think that we do have a lot of really good established employees at the University of Denver set up to support this. And so it really, I think, is outreach. I see some people on here saying, how can I learn more? How can I be a better, ally in this work? So, the immediate answer is reach out to us and we will be very responsive. I think the secondary role for us is to really start laying some good initiatives as we are on how we can start to really think through what is effective, looking at, what we know to be some of the research out there already around what is effective gender-based violence education. Are we doing it? Are we being comprehensive enough? And really, what are the light bulb moments for us that we have, that we could have been doing but are not? Those are still, I think, really our burning questions through it all.
Thank you so much, Molly. And I think that's a great way to wrap up our time here. We are at the noon hour. It's always unbelievable how fast these go. And there was truly so much information. This will be available to watch and share. Please feel free to do so. And a huge shout out to Emily, Molly, and Anne who joined the call. I'm actually going to drop Emily and Molly's information on their email addresses. They said if you have any questions, please feel free to reach out directly. So I'll put that on the chat here. And with that, I do want to ask as well, there will be there's a survey, and we want to make sure that we're best serving the community with C+B, and if there's anything that we can do better or talk about, we are happy to do that. And so there's a survey link there as well. Please feel free to follow us on social media. And thank you all so much again. This is not an easy topic. There's a lot of these proposed changes going on. So we just truly thank you for sharing your expertise, and thank you to all of those who joined us today for this conversation. Take care, all.